Access to Democracy is made possible thanks to the following organizations. Sheridan Dulas PA, a family and criminal defense law firm that has been serving clients in Dakota County and throughout Minnesota for over 40 years. Ranked a Tier 1 Best Law Firm by U.S. News and World Report every year since 2009. Sheridan Dulas are here to help you in your most difficult life circumstances. Established in 2007, 45th Parallel Distillery was among the first 50 microdistilleries in the United States. Based in New Richmond, Wisconsin, all aspects of production occur at their facility. If you're interested in learning more about the 45th Parallel Distillery, please check their website and plan a visit to tour their facility and taste their spirits. Truestone Financial, with locations in Minnesota and Wisconsin, has proudly served its members since 1939. Truestone engages, educates, and supports its members to ensure they have the tools to empower their financial well-being. Truestone Financial, your neighborhood credit union. Learn more at truestone.org.
Hello and welcome to another episode of Access to Democracy on this cold Minnesota winter day. I'm Steve Francisco, your host. It's a pleasure to welcome to our studio today a good friend of ours and a sponsor of Access to Democracy, our friend attorney Jeff Sheridan from the firm of Sheridan Dulas.
Yes.
Welcome back to Access to Democracy, Jeff. It's good to have you back on the show.
And it's great to be here. Thank you.
So for viewers who may not have seen your previous interviews on the show, one question I always like to ask guests is, what made you do what you do? What made you want to become a lawyer?
You know, I came by the lawyering part sort of through my genes. My grandfather was a trial lawyer. My father's a trial lawyer. My father died when I was 2 years old, and so my mom remarried a pilot. And so I ended up with the piloting part of my life through nurture, and the lawyering part of my life through nature. So I kind of came to it that way,
And not just to become a lawyer, but to become particularly a criminal defense lawyer, a very particular specialty in the law. What drew you to criminal law?
You know, when I was in law school, my entire plan was I was going to become a prosecutor, and then I was going to become a judge, and I was going to retire as a judge. But I needed money to get through law school, so I took a job in the federal public defender's office. It was part of the work-study program. Once I was there, probably, a month and a half into it, I thought, this is what I'm going to do.
You were hooked. You were hooked.
This is what I'm going to do.
And how long have you been practicing
law? It's almost 4 decades now. So I was sworn in 1987. Worked in the federal defender's office probably in 1985, 86, that era there. So, yeah, it's been 40 years.
And we should say your firm, Sheridan Dulas, is located right here in Eagan.
Right here in Eagan, Minnesota. We're a Dakota County firm, have been since 1980 when my original partner started the firm back in 1980. So we've been here quite a while.
Very good. So many people believe that they have some understanding of the legal process because they watch TV shows and movies. Many older people may have grown up, even I remember watching Perry Mason, who I think almost won all but maybe one of his cases in that TV series.
And he was fortunate enough that all but one of his clients were innocent.
Wrongfully
accused.
What are the odds of that happening in the law? But the question I want, these shows create impressions among people that are not always accurate. What do you believe is one of the most common misunderstandings about what the role is of a criminal defense lawyer?
Sure. Well, and I tell you, it's a bit of prejudice that we face every day in the courtroom, is that the judges who can't distinguish between us and our clients. But our job is simply to make sure that the system, that the due process guaranteed by the Constitution, is afforded to everyone who finds themselves at the pointy end of what the prosecuting attorney is up to. I always tell my clients, we're all expected to obey the law. And so that's what brought you here, is somebody's accusation that you didn't obey the law. But guess what? You're not the only player in this. Everybody in this is supposed to obey the law. So police officers, prosecutors, defense lawyers, defendants, everybody in the system has to obey the law. And there are plenty of people out there waiting to judge my client and decide whether or not he obeyed the law. My job is to make sure he's not the only one on trial, that the system is on trial every time somebody is accused of a crime.
That's very important because I think almost everyone has probably heard this concept that you are presumed innocent until proven guilty. But getting to that point of proving actual legal guilt is actually a complicated process, isn't it?
It is.
There are questions of the admissibility of different types of evidence. Certain evidence can come in, other evidence can't, right?
Yep, and even, a tiny percentage of the things that get charged out in this country actually end up in trial. And, there's nothing in our Constitution that talks about plea bargaining as part of our system of justice. It's something that's evolved out of, sort of practical implications. But every one of our cases, every case that comes in my door, I'm looking at what's that trial going to look like down the road. We might not make it that far, right? It may be that in the process of deciding who did and who didn't follow the law, that we find that the police officers didn't follow the law and that the court would then exclude evidence, which may weaken the case to the point where the prosecution can't even go forward. So the process, as Justice Coyne told us, justice isn't an outcome, justice is a process. And so every part of that process is important in determining whether or not somebody received justice.
And as a criminal defense lawyer, just like the prosecutors, you have an ethical obligation to represent your client to the best of your ability to afford them every legal defense that is available to them.
Correct.
So does it make you cringe sometimes when you hear people say, well, so-and-so got off a charge on a technicality? We hear this phrase all the time, people saying, well, somebody got off on a technicality.
And
what is your reaction when you hear something like that?
I tell them that I've never heard the Constitution referred to as a technicality. I like to think of it as the foundation stone of everything we're doing. So again, this isn't about whether my guy obeyed the law. This is about whether everyone is obeying the law.
And can the government prove the case, prove the charges that it's bringing?
Yeah, absolutely.
Because frankly, when you look around the world at different legal systems where it's very easy to imprison somebody and put them in prison, or under the image of a trial, which is less than fair, shall we say, that seems to be more the rule rather than the exception in most places around the world, isn't it?
It is, and we're fighting very hard to make sure that it doesn't become the rule here in our
country,
very own nation.
The challenges we're facing right now. But just that concept, that idea of the burden of proof, the government always has the burden of proof in proving that somebody did what they allege they did.
Yep, and I run into prosecutors who are very glib about that and just basically, well, your client has everything in his favor walking into the system. It's the presumption of innocence and a trial by jury and proof beyond a reasonable doubt. And the defendant doesn't need to raise a defense at all, doesn't need to open their mouths. I don't have to open my mouth during a trial at all. And it never changes the fact that the burden is on the state to prove guilt beyond a reasonable doubt. But I always tell people as well that, the title, the caption of the case is State of Minnesota versus my client.
Right.
And make no mistake, the awesome power of the state to have one guy, usually me, right, standing between you and the awesome power of the state of Minnesota. It is not something that we should just assume, the defendant's walking into this with some great advantage. Trust me,
right.
It's not.
And the government has tremendous resources at their disposal. They have
Absolutely.
resources of investigators and a team of experienced prosecutors and people who know the law very well and have been trying cases for a long time.
And none of which costs them anything, right? I mean, if a prosecutor is preparing their case and they're like, oh, there's a missing piece here, picks up the phone, calls the police department mobilizes whatever resources they have to go out and fill that missing piece. Whereas if I'm preparing a case and I see the same omission, Now it's a call to my client and saying, look, this would be helpful for us to have. Do you authorize me to hire an investigator? Do you have the money, the resources to hire an investigator so that we can send out somebody from our side to try to do that? It's the imbalance of power is massive.
Right. One of your specialties is defending people charged with DWI, driving while intoxicated, and DUI, driving under the influence offenses. In October, the Bureau of Criminal Apprehension discovered nearly 400 DWI tests from 8 jurisdictions across the state of Minnesota were reviewed after possible errors involving law enforcement operation of DMT machines was discovered. First of all, what is a DMT machine, and what is the nature of the errors that the BCA believe they uncovered?
Sure. So usually when people are in the throes of an investigation for a DWI, they're going to, the primary way of testing their alcohol concentration is through breath. So we have 2 devices that we use. One of them is the PBT, the preliminary breath test that gets used out on the roadside.
That's the one blowing into something.
That's the little handheld tinker toy. Right. So that's a PBT. And then once the arrest decision is made, they're brought to the station. They invoke Minnesota's implied consent law, and then they're asked to submit to an evidentiary test at the station. That's the DMT, the Data Master Transportable, so the DMT for short, is the evidentiary test that is supposed to be more sophisticated and of an evidence quality, right? So we've got the little device that gets maintained by police officers and stumbles around in the bottom of their squad car until they need it, and right. So that's one thing, and then there's what's supposed to be the more scientific test, the DMT.
Both are admissible in court?
No, the portable is only, theoretically, is only used for purposes of making an arrest decision.
An arrest probable cause. And
but once that decision is made, the only one that's admissible in a trial for a person being 0.08 or more is the result of the Data Master. So those machines are all supposed to be calibrated, both the tinker toy on the roadside as well as the evidentiary machine. But they use different processes, and the calibration solution, the gas that they use to calibrate to see whether they're reading accurately, is provided by laboratories in these canisters that are used throughout the state. The problem is that those canisters will fit both types of machines, both the preliminary breath test and the evidentiary breath test, but they're not the same. And so what had been happening is that officers had been using the gas cylinder from the preliminary breath test in the Data Master machine itself, and those are not certified to the same standard and whatnot. And so they couldn't establish that the machines were in proper working order. And so they went through and found the cases where they had obviously had the wrong canister, the wrong cylinder in the device, and those are the ones they came forward with and said, yeah, we're not going to stand behind those tests.
Now, have they discovered any additional instances in other jurisdictions beyond the 8 that were initially reported back in October?
The number has grown, and I think you said it's about 400 now. I think they initially, when they first announced it was in the 200s. So they're finding more and more of them as they're so they shut down breath testing until the devices were shown to be in compliance. And so one by one, the departments are coming back online, and as they're doing that individual evaluation, they found a handful of others. So I don't know that it's done yet, and frankly, in the world of breath testing, it's only one of the many problems that we have here with the Minnesota breath testing program.
So a key question that would occur to people, I'm sure, is
what if somebody was...
Yeah, do you have any cases that were clients or cases that were affected by this issue?
I'm in a group of lawyers who do this type of work, and I know many of them who have. I personally do not have a client who is in that pool.
And another question I think people would wonder, do people who had charges pending against them in these jurisdictions, are those cases being dismissed by those county attorneys, or will the defense attorneys move to dismiss them, or the court can dismiss them?
It's case by case, office by office, right? We got 87 counties in Minnesota. You got 87 different county attorneys. You got 87 different approaches to how they're handling the cases. Most of them, once the BCA has told them, look, we're not going to, if you put us on the witness stand and ask us, is this a valid and reliable test, we're not going to give you the answer you want. So it takes some prosecutors a while to get to asking them that question, and then the inevitable outcome is they'll probably dismiss the charge, reduce the charge, and negotiate something. But yeah, by and large, the government has acted, admirably in first announcing this and
the discovery of the error.
Right, yeah. And they say they announced it on their own. There were actually lawyers who were looking into it and prodding this, which caused them to look, and then so it wasn't completely on their own.
So another question for you would be not just cases that may be pending, but what about people who've been previously convicted? Has the BCA been able to establish a timeline to when the error in the testing originated?
Well, they have identified the sum that had gone to the point where the person had been convicted. And then those lawyers are bringing post-trial motions to vacate those and go back. And by and large, they're not meeting with a ton of resistance from the government. So,
because, I mean, it would seem that that's the very definition of reasonable doubt if you've established that there is an error in the testing that leads to someone's conviction, right?
For you and me, yes.
But not necessarily for prosecutors or
not necessarily. So
interesting.
They may point to other evidence and say, well, he was all over the road and he couldn't stand on one foot, and so therefore we were clearly going to get a conviction anyway, even without the test.
That's a good point, because you're not just relying on the test, but there are other circumstances involved that could lead a jury to conclude someone is in fact guilty.
Yep, it's possible.
Very good. Last question on this point. Are we confident now that the errors are no longer occurring?
Oh, I think, yeah. I mean, they shut down the breath testing and basically made each I mean, there are, Minnesota owns about 200 of these machines. I believe there's 165 of them in play at any given moment. And that before anybody was allowed to start testing again, they had to verify that they had the right canister in them.
Jeff, your firm's website notes that you are, quote, one of the only attorneys in the state willing to take DWI cases all the way to trial, which begs the question, why don't other lawyers take cases to trial, and why do you?
Well, it's probably, I've been told that there's just something wrong with me. I'm broken in that particular way.
You just like being argumentative?
I know from having done this for nearly 4 decades that the difference between, I always tell my clients, this is what's on the table. This is the worst thing that could happen if we get the crap beat out of us in a trial. And if those two things are hovering over the top of each other, then why would I ever relieve the state of the joy of beating the crap out of me in a trial? And there probably is something wrong with me. I love the fight. I will always default into the fight, okay? And until you can show me that something that's on the table is demonstrably, materially different than the worst possible outcome if I lost the trial, then we're going to have a trial. It's a bad business practice, okay? Because by and large,
it takes up time and
resources.
Well,
it takes up time, and you hire your lawyer, and generally you pay them a flat fee to represent you in the case. And so, frankly, from the business perspective, in dollars per hour, you're way better off pleading somebody guilty right out of the chute in the dollars per hour world. That's not the way I function. I went to law school because I really enjoy the practice of law. I love trying cases. And if somebody is going to make me an offer that basically is I should give up, they can enjoy 3-4 days of my company.
Can you give us a quick example of a case that stands out in your mind that you took to trial that may have gone up to the Court of Appeals or maybe even the Supreme Court? Are there any cases that fit that category, and why did you bring those cases that far?
Sure. Well, I've been to I mean, I've been to the Court of Appeals over 125 times. I've been in the Minnesota Supreme Court, which is a court that only hears the cases it wants to hear. I've argued before that court, I think it's going on 20 times now, twice to the United States Supreme Court. Again, it probably has something to do with me being broken in that particular way, but I think I really believe in this system, and it's hard for me in this moment in history because I've dedicated so much of my life to this system and trying to make it work. That it only works if there are people who are willing to go the distance, right? To say, look, our DWI law is a particularly troublesome piece of legislation for me. When I first started doing this, it was 7 pages long in the criminal code book. It's been struck down as unconstitutional 10 times since I started practicing law. I represented 8 of the 10 drivers involved in those challenges. And in that time, there were...
Where the state statute was struck down and had to be rewritten by the legislature?
Right. And so the legislature had 10 opportunities to say, you know what, maybe Sheridan's right. Maybe we should wait until after people are convicted before we start throwing punishment their way. And on 10 different after given 10 different opportunities to do that, have doubled down and said, you know what, let's just put a Band-Aid on whatever the problem was, and let's keep doing what we're doing. And so that in that time, it's grown from 7 pages, it's now 46 pages in the criminal code book, by far the most complicated law in the books. All because they want to be able to revoke your driver's license before you ever set foot into the courthouse. And
which creates all kinds of problems for somebody that, again, you are accused, not yet convicted, but you have a job that you have to get to, you have groceries, you have doctor's appointments for yourself and family members. Those are the types of issues that we're looking at here.
They are. And, anybody who's, grew up in the United States of America who believes in the presumption of innocence, but somehow they can hand out the punishment before you ever set foot into the courtroom.
Putting the cart before the horse in a way, isn't it?
Yeah. So, and like I said, 10 times the courts have ruled, and 10 times the legislature's doubled down and put it back together. So
it's no news to you, Jeff, or anyone else watching this program. We are living through a time right now where challenges to the rule of law are front page news literally every day, especially at the federal level, but also occurring in state courts around the country too. What is your take on where the state of our judiciary today and our promise to deliver equal justice? Isn't that more really aspirational than a fact, that we don't deliver equal justice to people based on disparities in income, based on racial factors, based on perhaps previous criminal convictions, other things?
Absolutely aspirational goals. It's a system that relies on the good faith of the participants. Everything in our government, right? All of the things that we see going on in Washington right now are all things that are taking advantage of all the little chinks in the armor, the little soft underbellies of democracy. And we have for 250 years relied on the good faith of people who come to government who are actually there because they have an interest in making their country better. Not for their own personal gain, but to make their country better. And
the idea of public service.
Yes.
Public service.
And all of those, again, if we assume everybody is a good faith actor, it's served us well for 250 years. But if somebody's not a good faith actor, if somebody is in it for their own aggrandizement, we are now being demonstrated all of the loopholes, the chinks in the armor that are exposing us to the things we see today. And it's happening largely with the permission of the Supreme Court of the United States. And so what we have now, frankly, if I were a state Supreme Court justice today, I would feel so empowered to step in because The federal Constitution, remember, only provides the minimum protection allowed by law.
State courts or state constitutions can exceed the federal
Yes.
Constitution.
So we have our
Right.
own Constitution, and maybe we can't save the 330 or 40 million people of the United States, but for the 5.7 million people who live here in Minnesota, we sure can. We can interpret our Constitution as affording greater protections. And so, like I said, if I were a state Supreme Court justice today, I would be setting that federal Constitution aside and looking really hard.
Jeff, that seems to many people probably to be counterintuitive, doesn't it? Because we're taught the U.S. Constitution is the supreme law of the land.
Yeah.
But people need to remember the powers of the federal government are enumerated, and the powers not reserved to the federal government are given to the states, right?
Yep.
Isn't that the basis for this idea that state constitutions can afford their citizens even greater protections that go beyond just what the federal Constitution provides?
Yeah, and it's, oftentimes we will sort of defer to the federal government unless there's a good reason not to, or to the federal interpretation of due process of law, of unlawful searches and seizures, all those things that we deal with every day in the criminal law world. But again, those are the federal Constitution provides the minimum protection. Mm-hmm. And boy, I tell you, like I said, if I was watching what was going on in Washington right now as a state Supreme Court justice, I would absolutely be looking.
You'd say it's time to step up to the plate.
This is why we have our own Constitution, right? So, do we allow masked law enforcement? Right? I mean, Minnesota has statutes that prohibit that, but we can certainly interpret our Constitution in a way that says, we don't have secret police.
Well, I want to ask you about that. This is all over the news these days, these ICE, DHS raids that are occurring, many of them most of them perhaps occurring without warrants issued by a judge, no arrest warrants, rounding up people based on the suspicion that they may be in the country illegally, snatching people off the street, pushing them into vehicles and taking them to detention centers, and then sometimes people being whisked out of the United States. Where is due process of law in that?
And that's why state intervention is required, right? To say, well, okay, you know what, ICE, you want to do that, but in Minnesota, we don't allow masked officers. In Minnesota, we don't allow unmarked law enforcement vehicles.
Right.
Okay? That's against the law in Minnesota. So somebody needs to step up and say, we're not going to permit that.
That's a really interesting point. And it really seems like we are at a turning point about what kind of country we're going to become. What kind of country do the American people want to have as their home? And are we going to abide by the tradition of the rule of law where everyone is accountable under the rule of law, including the highest government officials?
Yes. Yeah, this is going to end, right? In my view, the nightmare that we're going through is going to end. Always does. History, anybody who follows history knows that's going to happen. So the question is, what do we do on the backside of it, right? What is it that we as Americans want for our nation once all of this has been exposed? And how do we rebuild it?
Right.
And boy, that is going to be the question.
And it's not going to be easy, and it's going to take a while. The damage that's been done is significant, I take it, in your view.
Yeah, oh, absolutely.
Yeah. Jeff Sheridan, attorney at Sheridan and Dulas Professional Association, right here in Eagan, longtime attorney. Thank you for coming on Access to Democracy today to discuss these important issues in your role as a criminal defense lawyer. And thank you for being a sponsor of our program as well.
It's my pleasure. Thank you.